Daily cost list, item number 1.
Please, Lordship. In preferring the appeal, Lordship, against the impugned judgment 29/7/2022, an order of sentence dated passed by the learned Additional Deputy Commissioner, there is a delay of 517 days, Lordship.
Legally, brother?
Yes.
Delay may be condoned.
Mr. S.D. Upadhyay, learned Legal Aid Counsel, has submitted that sentence of dated 29/7/2022. Is it 29/7/2022?
Yes, Lordship. That is judgment and sentences.
Sentence of dated 2/8/2023. So, Padhyay, I was reading your petition, it says to 2023.
Paragraph 1 of your petition, condemnation application.
Paragraph 1, Lordship. Oh,
22, isn't it?
22, Lordship. So, 22.
Make that correction.
Yes.
2022. Huh? At the time of preference of this said appeal, a delay of 517 days has been caused, for which indulgence is sought for from this court to condone the same. Ms. R. Gurung, G, appearing for the state respondent, has no objection to E pre-made. Accordingly, on good grounds shown, the delay of the said 517 days is hereby condoned. Petition disposed of. Registry to diarize the main appeal. It can be admitted now.
My lord.
The appeal is admitted. That the lower court records be called for, and the appellant to prepare the paper book. The same to be done within 4 weeks' time.
Lordship, in LA matters, legal aid matters, the registry used to prepare the paper book.
That has been changed.
That is done always.
So on our registry to prepare the paper book. Since this is a legal aid matter, seems to be done within 4 weeks. This is the matter thereafter.
Deeply obliged.
Item number 2.
Corrected.
Sincere apologies, my lord. The mistakes that have come up in both the applications, if your lordships allow me to correct it by hand, my lord, matter can come up after 1 or 2 days, my lord. I'll just do the correction, my lord.
By the legal counsel for the applicant, this is matter on 2 days.
This 5th, my lord.
This is matter on 7th.
My lord. My lord, kindly permit me to make the corrections with hand.
The applicant is also allowed to, the legal counsel is also allowed to make correction in the said application.
Item number 3.
Yes, Mr. Let's go first with 281.
281, my
What is
lord.
required here?
They had, just before the vacations, they had filed an affidavit, bring on record certain documents. I was required to file an affidavit in reply to that. That affidavit I have filed, my lord, and it is on record. My lord, in this particular matter, when the Supreme Court had remanded the matter back to this Honorable Court, this Honorable Court was to decide whether the CPF provisions have been implemented by the government in letter and spirit or not. But in my rejoinder affidavit that I have filed, I have brought on record to show that although they have constituted a society to manage the fund, but that society is yet to be registered, the agreement with the bank is yet to be executed, and thereafter what is required is that a fund has to be created which will be managed by the particular bank. This part of the work remains as of today also. The provident fund amount which is supposed to be deposited in that particular provident fund account is not being done. It is still being deposited in savings bank account. Now once, my lord, that fund is brought into existence, perhaps this petition can be closed is also my submission. So therefore, my lord, if the government takes up that part of the work, and if it can be...
But you could have got instructions, see. You see. You are required to do certain things which you have not done. End of the report.
Item number 4.
Obliged.
My lord, this matter in the last occasion, lordship recorded both the parties agreed to proceed the matter on merits, my lord. Before I take lordship to the impugned judgment,
You were not implemented before, your lordship, in the writ petition, and that petition, your lordship, is will be filing, your lordship.
direction given, direction complied with, partially they have complied with. At this stage, my lord, how can they file the application for implementation?
Because your
Lordship may hear me first, and there may be a question if arises that the implementation of third party arise. Lordship may do that. But Lordship may need to hear me.
Much affected party, your lordship, necessary party, your lordship, because what happened, the government has taken a decision to dismantle.
What is their role in the
Lordship, because these are the people who had donated the land, your lordship, to the state government. Because of in view of the fact that the writ petition has been filed claiming a huge compensation, your lordship, then lordship, we have taken a decision to dismantle the project, your lordship. So they will be very much affected, your lordship.
Lordship may hear me, my lord. They never take that plea in the earlier round of the litigation.
And they have not implemented also, your lordship. We have not
correct.
taken the plea, but they have not, the writ petition also, they have not.
the dam has been constructed.
Constructed, they have been utilizing from 2011.
Lordship, the cost of the project is only 10 crores, your lordship. And we have to pay the compensation, your lordship. It will come to 100 crores, your
They
lordship.
cannot hijack in the writ.
There is
writ
no
proceeding,
justification,
writ
your
appeals,
lordship.
my lord. Direction has been passed. Why did it not seek for implementation in the initial 2016 writ petition? If I fail to implement the right persons, they never take. Matter went to the division bench also, they never take that plea. Then they took 2 years again after single division bench direction to take decision. They took a fresh decision to acquire my land, and there the delay. I filed a second writ petition. Second writ petition also, they never take that plea. Matter was adjudicated, my lord. In the learned single bench also, they never addressed that issue.
But you see, Mr.
In fact, your lordship,
Mr. Sangru, you see, if because of the outcome of these proceedings, somebody's right is materially affected,
Right.
that has to be considered.
My lord, therefore, lordship will appreciate whether it will be affected or not. After hearing the parties, lordship will come to know.
Can we prevent them from filing an application?
My lord, that is true, but there is a stage. My lord.
Right now, prayer is for filing an application. Can
My
we
lord.
prevent that?
No.
What should be the matter? Whether we allow it or reject it, that will be different.
That is true, but they have complied with the single bench direction.
Mr. Sangru, what you can do is, as my brother has said, let the application be filed. You make an objection to it.
My lord, that will
It will be heard.
my lord.
Another-
It's lordship discretion.
The point is,
Lordship discretion.
we have to, you see, we have to give a level playing field to all concerned.
My lord, I bow down with that, my lord. I bow down with that. But the attempt made by the government is to frustrate,
there is,
to delay the matter,
that is out
to
of
delay the
question.
matter.
Yeah.
That is for
And whether application will be accepted or not, lordship has pointed out
That will be for the
correctly.
court to decide.
It's lordship's discretion. But at this stage, my lord, when the single bench direction is complied with, my lord, allow me to open the merits of the matter. Lordship will come to know, and I'm very sure that it is not required. It is not required at all. There is no third person who is claiming. Throughout, my lord, they are blowing hot and cold.
We are not
So,
doing
Lordship,
hot and
allow
cold,
me-
Your
allow
Lordship.
me to
Kindly
offer-
see, this fact also was concealed, Your Lordship. The agreement
never,
executed
never,
between
never.
the petitioner and the state government has been concealed, Your Lordship. Kindly see,
They
Your
never.
Lordship.
I don't-
That
they-
is there was material suppression of material fact, Your Lordship.
Let-
It
let
was
him-
never brought before the honorable court.
with due respect to learned AG, my lord, at this stage, my lord, separation of facts,
We'll give him
that cannot be done, my lord.
we'll give him limited time to file the application. Question will be heard. You do that within 2 days.
Yes, Lordship, yes.
It copied him.
Lordship certainly will.
Before the matter is heard on merit, Mr. Indishulai Leonard AG has submitted that the state respondent may be allowed to file an application for impleadment of proper and necessary parties who have been left out in the proceedings, but whose rights will be materially affected in course of any decision reached in this matter. In course of though the same has been vehemently opposed by the learned counsel for the appellant, learned senior counsel for the appellant, has, however, in the interest of justice, is inclined to allow the preamble on the submission of the learned AG. The said application is to be filed 2 days from date. The appellant may file a rejoinder if file a response if so decide.
Lordship is recording my objection also.
That has already gone.
Already recorded.
This is matter after 1 week.
After one.
Oblige, Your Lordship.
Second call item number 3.
I think we are not getting the link.
Perhaps
You'll be here, Mr.
today, but I can be here.
You can join by VC day.
If Lordship, if it is convenient for the 14th, my Lord, I can be here on the 14th. There will be no difficulty because we have a holiday day in the Guwahati High Court. So I can be here on 13th or 14th. 14th would be convenient if convenient, Lordship.
On pre-made by the parties, let's this matter on 14th.
Lordship, I have a small player in this, Lordship. Lordship, what happened, these ad hoc teachers, for these ad hoc teachers, we will be filing one affidavit so that the ad hoc EPF fund can, we can bring them under the EPF, thing. So, I would like to file one affidavit.
Well, that would be, I think, subject to
Place end of the government so far as the ad hoc teachers are concerned is that they would not be covered by this CPF. Now, once a person is not covered by the CPF and the institution confirms to the provisions of the EPF matter, they would be covered up to the extent of 15,000 rupees under the EPF. So the deficit grant in colleges admitted by the government that would be covered by the CPF, whether it is being properly implemented or not. So far as the ad hoc grant in colleges are concerned, EPF wants to take a stand. if I understand correctly, that up to the 15,000, they would also be covered under the EPF. That would give them some respite, my lord, of not having any sort of a provident fund at all. So her affidavit perhaps would be.
Why at this point of time?
Lordship, actually we were waiting for the state to take a stand on what the size is here. So,
I'm sorry, Lord, I was in the other court. Yes, my Lord, this matter, my Lord, the petitioner has sought time for filing rejoinder, my Lord, but the very short one, my Lord, in this case. Issue is, my Lord, that we have complied with the order of the Supreme Court, and to that extent, my friend has also agreed. The other connected matter, my friend was saying that he has used, and that the 360, my Lord, writ petition number 360 of 2020.
Mr. Kumar, let us first deal with 281.
Yes, sir.
I think Mr. Majumdar has got a point to make.
My lord,
Where is your rejoinder?
I would just differ with the learned AG, my lord, when he says that I agree that they have complied with the orders of the Honorable Supreme Court. That was never a statement made.
Where is your rejoinder?
My lord, rejoinder was filed on the 14th of December 2023, my lord. The last day the matter had come up. Lordship finds it.
This one.
Now, if Lordship would kindly have the second page, para 2. With regard to the contents of paragraph 2 and 3 of the additional affidavit, the answering deponent states that the writ petition was filed with the grievance that the respondent authorities are not implementing the provisions of the Meghalaya Non-Government School and College Employees Centralized Provident Fund 1969. In the writ petition, the Petitioner Association has brought in a grievance that the respondent authorities were not maintaining the CPF in any scheduled bank as defined in the Act of 1969. The Act of 1969 defines a scheduled bank as a national bank that has entered into an agreement with the government to deal with the provident fund of aided educational institutions. In the affidavit in opposition, the respondent authorities have not asserted they have entered into any agreement with any nationalized bank to deal with the centralized provident fund as required under the Act of 1969. The respondents have asserted that a fund has been constituted and have referred to Annexure R1, which is a notification of 29th of May 2023. The said notification specified that the fund shall be created with the existing fund of the subscribers, the contribution of the employer and the subscriber of the constitution of the fund, and grants in aid. It is stated by the deponent herein that till filing of this affidavit, there is no agreement by the government with any nationalized bank to maintain the fund in issue, and to which is maintained in savings account have been credited to the provident fund or the contribution of the employer, and the subscribers are still being made, subscriptions are still being made in the savings account. Therefore, the answering deponent denies that the respondents have implemented the provisions of the Act of 1969 in letter and spirit. It is stated that the grievance of the petitioner association have not been redressed, and the respondent authorities remain liable to be directed to implement the provisions of the scheme by entering into an agreement with the nationalized bank to deal with the centralized provident fund, to transfer the existing fund of the subscribers and the future contribution of employer fund. My lord, it is relevant to note here that the respondents are referred to a communication dated 17th of November 2023, whereby the approval of the bylaws of the Central Pension and Provident Fund scheme was conveyed by the Learned Advocate General, wherein it has been stated that the bylaws would be registered in due course. It is thus an admitted position that the bylaws of the trust have not been registered till the 17th of November 2023, and there is no assertion by the respondent regarding any further action being taken in that regard in this affidavit. It is stated that the petitioners in the writ petition have made a specific grievance regarding the deposits of the contribution of employer and subscriber into saving bank account maintained in the nationalized bank. It is stated that till filing of the present affidavit also, the contribution of the employer and the subscribers are still being deposited into the same accounts as prior to filing of the writ petition, and therefore it cannot be asserted by the respondents that any of the grievances of the petitioners have been redressed by the respondents. And my lord, for the persons who had joined service after 2010, that the respondent authorities are yet to implement the orders given by the government in respect of the employees who had joined their service after 1/4/2010 by a notification dated so and so annexed in the Annexure R1. The NPS has not been implemented, although my lord, that would take some time because these people are yet to retire. The scheme can be made implementable during their course of service. My lord, if laid down by the Act under issue is that there has to be a centralized provident fund to be governed by a board of trustees, and a provident fund account is to be maintained in a nationalized bank which has entered into an agreement with the government. This part done, my lord, the transfer of the funds, deposit, these are all matters of the future which can be taken care of the government by the board. Although the board of trustees has been formed, that particular trust has to be registered with the register of societies, and thereafter it can enter into an agreement with the bank to maintain the provident fund. That part remains, the registering of the trust and entering into an agreement with the bank. Once that is done, the fund comes into existence with the bank, and that is where, my lord, perhaps if even till that extent the government works, the writ petition can be closed, because the rest of it will be the not going to. When we approached the Honorable High Court, when the Honorable Supreme Court was approached, Honorable Supreme Court in its order has said to what extent it has not been implemented. From the year 2002 onwards, in various litigation, government has said we have implemented, they are getting it, but the manner in which it had to be implemented was not being done. Saving banks accounts are being maintained where the fund is going into.
Yes,
which is not a
Mr.
provident
Kumar,
fund.
what do you say?
Yes, yes, Lord. Lordship, kindly first see the order of the Honorable Supreme Court, which is at page, my lord, 37, 36, 36 in 360, my lord. And then in the other one, my lord, is in 281, my lord. This is the writ petition on remand by the Honorable Supreme Court, my lord. Page 49, my lord.
Yes.
And your lordship will see, feeling, first paragraph, feeling aggrieved and dissatisfied with the impugned judgment and order of 1/11/2018 passed by the High Court of Meghalaya at Shillong in writ petition 281 of 2017 and 360 of 2017, by which division bench of the High Court, while allowing the said writ petition, has issued the following direction: the state of Meghalaya has preferred the present appeal, my lord. Your lordship may skip this part, and then the parties have been heard, my lord, and then your lordship will see the paragraph 8 at page 53. Paragraph 8, which is your lordship is currently adjudicating.
Yes.
Learned counsel appearing on behalf of the original writ petitioner has also conceded that writ petition before the High Court and the grievance on behalf of the original writ petition is be confined to non-implementation of provisions of Assam Act 1969 by the state of Meghalaya by enacting Meghalaya Act 1969. He does not praise any other relief, including implementation of contributory provident fund. All prayers have been given up by the petitioner before the Honorable Supreme Court, and the only thing which is now pending before your lordship's kind consideration is non-implementation of provisions of Assam Act adopted by enacting the Meghalaya Act 1988. Paragraph 12 is the remand order. Of this paragraph 12, lordship has taken note of paragraph 8, paragraph 12, my lord. Matters are remanded to the High Court to consider the grievance on behalf of the original writ petition with respect to non-implementation of Meghalaya Act 1969 and Provident Fund scheme under the aforesaid Act, if any. To that extent, it will be open to the original writ petition to amend the writ petition, to which it will be open to the state to file the counter. It is specifically made clear that remand shall be only to consider the implementation of Meghalaya Act 1969 and Provident Fund scheme thereunder. So remand, my lord, is confined to this aspect of the matter. Now, and these two writ petitions have been filed, my lord, because the other, and if your lordship will examine the prayer of the in the writ petition is much beyond the remand order is passed by the Honorable Supreme Court, and my humble submission that prayer is not maintainable, my lord. Kindly see the prayer at page 44. Prayer 1, my lord.
Yes.
Directing all the respondents to take immediate steps to strictly comply with the applicable provisions of Contributory Provident Fund scheme, which was adopted by Government of Meghalaya. My lord, this prayer, your lordship has noted, has been given up before the Honorable Supreme Court, and Supreme Court has said that 1969 Meghalaya Act and Provident Fund Act to be implemented. And kindly see the paragraph 12, where paragraph 8 and 12, my lord.
This is the amended writ petition.
Yes, my lord.
This is the amended writ petition, my lord.
Yes, please continue.
Kindly see page 54, second line of the top. He does not press for any other relief, including implementation of contributory fund scheme incorporated under the Assam Act. And first prayer of the petition is contrary to what has been given up before the Honorable Supreme Court. And in my humble submission, my lord, prayer number 1 of the petition is not maintainable, because it is against the order and direction of the. Now, my lord, direct the respondent to ensure that college teachers of deficit grant in aid colleges are given their due benefit under the provisions of aforesaid scheme with effect from the date. So this prayer 2 is also not there, my lord, because it is connected to. Then 3, further direct the state respondent to ensure the effective penalties are levied on all respondents who have failed to comply, my lord. 4, further direct the state respondent to formulate, finalize a scheme for effecting post-retirement social scheme. My lord, again, this is beyond the. 5th, my lord, directing the state respondent to implement state pension scheme. This is also beyond, but this part, my lord, 5, second part, my lord, which in my humble submission may come. Directing the state respondent to implement the state government pension scheme for teachers in deficit grant as applicable to employees of government college in case they fail to effectively implement the Meghalaya non-government school centralized, which remains to be adjudicated by your lordship, is the implementation of Meghalaya non-government school college centralized fund scheme. And on this, my lord, if your lord, first order of your lordship was 6 September 2023, 6 September 2023, the lordship's order with regard to implementation. Or before that, my lord, kindly see 6 July, I'm sorry, my lord, kindly see 6 July. Because first order is of 31st May when notifications have been placed. 31st May, my lord, before your lordship. 31st May, if your lordship will kindly see 31st May, because there are 3 orders which are relevant for your lordship's kind consideration. 31st May.
Yes.
The state says that a notification has been issued on May 29, 2023 by Education Department in supersession of previous notification of 13 April 2018. Such notification provides that all employees of deficit colleges should be included in new pension, converting the contributory pension with effect from 1st April 2010. Accordingly, the employees are required to provide NPS facility to employees, failing which employee will be held responsible. A second more important notification has been issued also on May 29 to 2023 pertaining to non-government schools and college employees appointed to sanction posts who joined regular service prior to 1st April. The writ petitioner says the second notification covers the entire area of dispute in these proceedings. Since copies of such notification have been made over to Advocate for Petitioner Association in court today, let the matter appear in fortnight here in association respond to. In the meantime, association has any suggestion, the same may be directly communicated to Secretary to Education Department prior to adjourn date, my lord. So your lordship may kindly take note of this fact, second paragraph. Important notification has been issued on May 29 pertaining to non-government schools and college employees to sanction posts who joined. That second notification covers areas of dispute involved in these proceedings. So notification has been issued implementing 1969 Act. My lord, kindly see the next order in this line of.
Where is this notification?
I'll place, my lord, that is part of the additional affidavit. I'll place, my lord, I'll just show the orders and then I'll place that, my lord. Kindly see 6 July order of 2023, your lordship's order of 6 July.
Yes.
The petitioner submits that upon the remand matter, Supreme Court steps have been taken by the state government to redress the petitioner's grievance. When I say that petitioner's grievance has been redressed, I was saying in these contexts only, my lord. It is also the common submission of the parties that a board of trustees has been set up under the Meghalaya non-government Employees Provident Fund Scheme 1969 to implement the provisions of the Act. Accordingly, at the request of parties, the matter is adjourned. So, my lord, the notification has been issued, trustees have been appointed, my lord, and now we see. So this 6 July and 1st May, lord, it is there, and then your lordship will see 6 September. first notification was issued, my lord. Then trustees have been appointed, and 6 September 2023 order, my lord. It is submitted 6 September 20, your lordship, 6
Yes.
September, 3 order for the 1st May, 6 July, and 6 September, my lord.
Yes.
A copy of the draft, your lordship, it is first paragraph. It is submitted on behalf of a state that pursuant to creation of trust in terms of the order of Supreme Court, draft rules have been prepared. So we issued notification, my lord. We appointed trust, and the draft rules have. Will respond to the same whether directly to the state or by way of affidavit filed in present proceeding. It is further submitted on behalf of petitioner. So far as the ad hoc grant are concerned, there has been no action by state. That this is a second writ petition, my lord. If such is the case, state should appropriate measure interregnum before the matter appears next, my lord. Now, my lord, kindly see my affidavit of 29th November 2023. I'm sorry, my lord. There is an additional affidavit which places that additional affidavit in which we have placed everything, my lord. My friend can help me in place because by way of
Yes.
my lord status
Additional
my
affidavit.
lordship. Yes, my lord. In that, my lord, we have placed the notification. And somehow placed the notification, my lord. We have placed the draft rules, and we have placed all these things. In the light of all these things, my submission is 281, my lord. What my friend is asking for day-to-day implementation of the. Wait, that. Sorry.
This is the notification.
Yes, my lord. I'm sorry.
Annexure
I'm
1.
somehow missed my file, my lord. But that notification is there. My friend can help me with the notification and the affidavit. But I placed it on record, my lord.
Mr.
Notification
Majumdar,
is there.
You have this with you?
Yes, yes, I have.
The affidavit.
It is a
dated
page, the additional affidavit at page 6, my lord.
Yes, 6 is the notification.
Yeah,
Yes. Affidavit. Yes, your lordship has seen the additional affidavit at 29th May, my lord, in exercise of power conferred under section so and so, 1969, is pleased to constitute a fund to be called the Meghalaya Non-Government School and for all non-government college and appoint sanction posts who join service so and so. So we have, my lord, notified the in terms of 1969 Act. That was the order passed by the Honorable Supreme Court, and that was also. Then, my lord, kindly see minutes of the committee at page 7. Board of Trustees. Now, Board of Trustees held on 30th June 20, a committee. Board of Trustees, my lord, will function of Board of Trustees memorandum. So then, my lord, I have shown the order where Board of Trustees have also been constituted, which was duly one of the petitioner is also, if I'm not wrong, my lord, who is before your lordship, is also part of the Board of Trustees, my lord. He is part of the Board of Trustees. Now, trust has to, my lord. Bylaws is at page 17, my lord. All these aspects, my lord, because this is a law in the form of continuing mandamus, my lord. They want that everything, whatever trustees are doing or whatever is being done, that is required to be monitored by this honorable court. In my humble submission, my lord, my case was that the trust has been constituted, bylaws have been framed, rules have been framed, and order of the Honorable Supreme and have been implemented, my lord. There will be the transfer of bank account. There will be several issues which the trustees will be facing. The lordship may issue direction to trustees to do the needful.
What about the issue raised by the petitioner as far as the
regarding a rejoinder affidavit, my lord? So these are the functions which are
as far as the agreement with the centralized or nationalized bank is concerned.
So because that will be done by, my lord, trustees of the Board of Trustees, my lord. Now the ball is in the court of Board of Trustees. Everything, there will be various steps. The persons will be transferring. All these things, your lordship may, because the writ petition in my humble submission can be disposed of with the direction to the Board of Trustees to do the needful within a 4 weeks or 6 weeks or 3 months, my lord, depending. So on the core issue is whether we are implementing 1969 Act or not. We have issued notification, my lord, which my friend has accepted it. We have constituted the trustees. One of the petitioner is, if I'm not wrong, is also part of the trustee, and some government officials are there, some elected representatives. So every other aspects of the trust, will, because it's a usual trust where trust has to implement these policies, my lord. So I was putting a question to myself, because now what my friend is saying, that monitor the function of trust on day-to-day basis by this honorable court by the division bench. When the remand order
That may not be necessary.
that, in my humble submission, that may not be necessary. Your lordship may pass a blanket order saying that all steps, whatever steps are required to be done, it should be done within a period of 3 months. That will be the end of the matter, my lord, because your lordship.
What is your response?
My lord, I'll have a response to that also, but from the initial, my lord, if I come to my reply, the Honorable Supreme Court's order, my lord, if we have a relook at it again at page 55, my lord, of the writ petition. Lordships will kindly have page 54 for a moment, page 54. It was pointed out by the learned AG at the top paragraph, my lord. The Assam Act of 1969, adopted by the state of Meghalaya by enacting the Meghalaya Act 1969. He does not plead for any other relief, including implementation of the Contributory Provident Fund Scheme incorporated under the Assam Aided Colleges 1961. You will note, we have not paid for anything in this writ petition with regard to 1961 Assam Government Aided College. Now, if Lordship comes to page 55 for a moment, the fourth line from the top. However, it is specifically made clear that the remand shall be only to reconsider the implementation of the Meghalaya Act of 1969 and the Provident Fund Scheme framed thereunder, if any, only, and the High Court, on the basis of the pleadings, even after the amendment, to consider which part of the Act scheme framed by the Meghalaya Act 1969 has not been complied by the state. Now, if Lordships kindly come to page 74. I'm sorry, madam, not page 74. I'm extremely sorry, madam. Page 80. This is the Meghalaya Non-Government School and College Employees Centralized Provident Fund Scheme in 1969. This act, my lord, at page 81, 2C, speaks of the Centralized Provident Fund, means the fund established under section 3 of this act. Lordship would find at section 3 at page 82, the bottom part, the state government may by notification in the official gazette constitute a fund to be called the Meghalaya Non-Government School and Colleges Employees Centralized Provident Fund, wherein shall be credited so and so 1 to 3. Now, my lord, this notification is there. Whether it is gazetted or not, I am not very sure, but that notification under the act has now come. Now, if Lordship would kindly have the scheme which was framed under this particular act, if Lordship has page 86. Bank of India Act, which has entered into an agreement with the government of Meghalaya, undertaking to deal with the Provident Fund in aided high school, middle school, according to the rules contained in the Education Department rules and orders. Now, this agreement has to be with the government of Meghalaya, not with the Board of Trustees. It does not speak of the Board of Trustees entering into the agreement. So that part remains to be done by the government, not the Board of Trustees, in my humble submission. So shifting the entire burden to the Board of Trustees and the government of Meghalaya stepping back is not going to help the situation. It is the government of Meghalaya which is to enter into the agreement. Thereafter, Lordships will find the in our prayer in the writ petition, what we had sought for in the amended writ petition is not what is presently shown to be. It is directing all the respondents to take immediate steps to strictly comply with the applicable provisions of the Contributory Provident Fund Scheme, which was adopted by the government of Meghalaya along with its amendment in so far as the teachers of deficit grant in aid colleges in the state of Meghalaya are concerned, with effect from the date on which such scheme was required to be effective. For that, my lord, if we again come back to the Meghalaya scheme at page 80, Lordships will find at section 1 subsection 3, it shall come into force on such date or dates as the state government by notification in the official gazette appoint, and different dates may be appointed for different categories of schools and colleges and different provisions of the act. These notifications have not been brought on record. Therefore, my lord, when at the very initial stage, if lordships would have the statements made by the state government at different times before this honorable have the orders passed by this honorable court at page 127, my lord, a division bench judgment. Page 127 of the repetition. Has the last paragraph. However, before parting with the records, considering the submission made before us, we expect that the state of Meghalaya shall take a conscious decision in the matter, considering the service condition and other relevant factors governing the teachers serving in deficit colleges in the state of Meghalaya. Here was a scheme, my lord, here was a case where the persons were asking for implementation of the of pension and EPF. This honorable court in a division bench has held that the government should have taken a conscious decision to work out the service conditions of the deficit colleges. Now, since in the honorable Supreme Court we had given up the claim for implementation of the Assam aided colleges rule 1961, that printed repetition. Thereafter, in their affidavit in opposition, they have annexed a judgment of this honorable court, my lord, which we at that point of time had also annexed. Lordship will find at page 54
of the writ
of the affidavit in opposition. Running page would be page 54. Otherwise, of the affidavit in opposition, it is page 11.
Yes, sir.
I am sorry, my lord, page 54 of the affidavit in opposition.
Page 54.
Page I'm sorry, my lord, page 45.
You're referring to just a moment.
The affidavit in opposition filed by the respondent number 1 and 2 on 25th of January 2023, my lord. It starts at yes. Lordship finds that affidavit in opposition filed on 25th of January 2023. And there at page 44, I am trying to refer, my lord.
This is 27th January, not 20.
My lord, perhaps filed on 27th. My lord, copy was served to me on 25th. So
Yes,
need
yes.
to be filed on. Now, if lordship comes to page 44, my lord, this is a writ petition of 2006, which was disposed of on 18/11/2013. Para 3, my lord. Brief facts of the case are that the petitioner, St. Anthony's College, is a deficit granting aid college having teaching and non-teaching staff of 150. It is stated in the writ petition that the college receives granting aid from the state government regularly, out of which full salary to the teaching staff against the sanctioned post is paid. It is further stated the fee of the students is fixed by the government and 60% of it is remitted to the government. It is also stated that the St. Anthony's College is covered under the Contributory Provident Fund scheme right from the beginning. And death cum retirement scheme of the government of Meghalaya is also applicable to the employees, as the institute is deficit granting aid institution. The contributory provident fund amount, for short CPF, is deposited and controlled by the regulations applicable to it. Then lordships may like to have at page 47. In additional affidavit, lordship has paragraph 5. Page 47, paragraph 5. In additional affidavit filed on behalf of the principal of the petitioner's college, it is stated that during the pendency of the writ petition, tri-party meeting involving the state government officials, the Assistant Provident Fund Commissioner, and the representatives of the college principals was held on 2011-2009 to discuss the social security benefit scheme to the colleges. Copy of the resolution passed in the said meeting is annexed as Annexure 5 to the additional affidavit. In the said meeting, the government agreed to deposit rupees 1 crore as corpus. Thereafter, I am just reading the relevant portion, my lord, just to show Several times it has been placed before this court that we are implementing it. It has been implemented. We are doing everything we can. But from 2002 onwards till date, even that agreement with the government is yet to, my lord, come on record. Lordships will kindly have page 54.
So that agreement as far as the government and the bank
It is an agreement between the government and the bank.
Right.
The Board of Trustees has got nothing to do with it. They will simply manage that fund once created. Lordship will have page 54.
So, Mr. Majumdar, you see,
My lord.
to cut it short, we are now at a point where your assertion is that the government, state government, and the bank, centralized bank, the agreement is not yet been executed.
Once it comes on record,
The AG would say otherwise.
the AG, my lord, perhaps, I do not know if you can say beyond the act, my lord, I don't know.
I have no, so far as if my friend's limited grievance is that there should be agreement between government and the bank for this creation of this. I have no, I will not stand in between your lordship direction to the government. Lordship may issue direction, but your lordship kindly see, because there will be some confusion, my lord. Kindly see the rules which are at play of the additional affidavit, bylaws, my lord. Kindly see bylaws.
Page?
Page 17 of the additional affidavit. My friend was part of this minutes, my friend's client. Page 13 it starts, my lord.
Mr. AG,
Yes,
let us make it simple.
yes, lordship.
This court is made to understand that there is, no conflict
Of interest.
or dispute as far as the
Yes.
both parties are concerned.
My lord, yes.
As far as the welfare of the teachers are concerned.
Yes, sir.
It is only now what we are made to understand is only in the manner of implementation to comply with the relevant regulations and provisions of the Act.
Yes, sir.
True, my lord, yes.
Yes, sir. For that purpose only, because for that purpose of implementation only, my lord, I was trying to place the rule. Because what my friend is saying, that trust has no say in all these matters. There, I just wanted to show rule of the, but if direction is also issued, my lord, to the government oblique the competent authority, that will also be suffice to dispose of the writ petition to this writ petition.
Mr. Majumdar has led us to the provision of the Act, isn't it?
Yes, my lordship.
says
There
it has
also,
to
my
be the
lord,
government.
lordship, I can show that, that there is some, because schedule back, because what has happened, my lord, that's why earlier that is a 69 system, my lord. Now the trust will be, this particular bank account will be operated by trustees.
But there has to be a provision for that then.
There has, that's why I wanted to show that, my lord, that
That would require amendment of the Act then.
If
the act, my lord, if your lordship will see, your lordship is right to that extent, but if your lordship will see the act purport also, which my friend has shown at page 81, my lord, kindly see the, I'll take your lordship to the, if I'm not wrong, page 81, where my friend has shown the provision, my lord, relating to schedule bank.
yes, page 88
88,
is the
sorry.
definition.
Yes,
The definition is page 88.
yes,
this-
lordship, kindly see the definition.
This is your
My writ petition, my lord, in my writ petition,
Yes.
page 88.
This is by OM is basically executive instruction by in state of Assam, my lord. Aswal state of Assam. And then your lordship will see, so this is not part of the act. This is part of the amendment is being carried to rule,
Yes, I think
regulation,
Mr.
statutory.
Majumdar, the EG is correct. You see, these are rules,
My lord,
executive directions.
yes.
So the government can amend the rules
Yes, yes, they can. But as they
to
stand,
say
as
that
of today-
say that either, as Mr. The AG has submitted, to say that it is either the government or an appropriate authority.
or inappropriate. So be it, my lord.
Yes, sir.
So be it. But
That is-
what is the call? Today, the requirement of the day is the identification of the fund in a particular bank with the government. This is, my lord, only operation part. If they make a flaw in that, we have an option of coming back. If they,
We will allow the government to, to do the needful as far as the agreement is concerned.
my lord, yes. That part done, my lord. Perhaps we would have
The rest will follow.
this
And
writ petition
only
would not
concerned,
perhaps continue.
not only I am concerned with this part, because the writ petition may not be required to be pending for the reason, may not, that the Honorable Supreme Court, while passing the order, gave the outer limit of 6 months to dispose of the matter. When parties are having consensus ad idem, that the notification has been issued, rules have been framed, trust has been created, And if my friend is having with regard to opening of bank account, your lordship dispose of this writ petition, giving direction to the government appropriate authority to open the bank account and do the needful. That is the only, because with the consent also this order can be passed. We have no issue on that point, my lord. So at least one writ petition and the direction of the Honorable Supreme Court in this matter will get complied. If your lordship will see page 55 of the writ petition, my lord, where the direction is there. High Court to decide and dispose of the writ petition on remand within a period of 6 months from the date of
Mr.
this
Kumar, we know very well that is there.
That is
That is
the-
there.
and
But
what
it
has
is- it is
happened
So
subject-
then we have reached on
it is-
consensus,
it
my
is
lord.
always
Everything
it is subject to the pace, I would say pace of the proceedings.
yes, your lordship, that is there. Please.
So, Mr. Majumdar, you agreed on that?
I submit to any of the directions that this honorable court would pass.
That is what we, as
There is no
has
difficulty.
been considered by the state, the only direction to be given is for the said agreement with the centralized or scheduled bank to be carried out by the government or an appropriate authority. It may
And
be,
Board of
it may
Trustees
be
there.
it may be the trust or any other authority for that matter.
Yes, yes, yes.
My only prayer would be, my lordship sets out a time frame for them to come to a decision, at least as to who is going to execute the agreement and
That we
that
will,
agreement
your
part.
lordship kindly give sufficient time. Within 3 months, we will do the everything.
And
my lord.
observation.
Why would an agreement take 3 months time?
No, because my lord, this is a new trust, rules, regulations. Your lordship may give shorter time also. I have no issue, my lord. Your lordship may decide. Sometimes we pay longer time, but your lordship may give shorter time also. There is. I
This
bow
issue
down
is
because
alive from around 2002 onwards.
no,
So,
this
I'll leave it to
thanks
lordships.
to
And
thanks to
if I may
Sundar
just
and
pray for an
their thought.
observation from lordships that once the agreement comes into existence, lordships should express an expectation that they would bring into force the other part as soon and as convenient for them, because people are retiring in the meantime from 2015 onwards. They are neither getting back their provident fund nor do they know that whether they would be in that provident fund or in some other scheme that the government would like to place them into. So a decision, a time frame and an expectation, my lord, that they would do it at the earliest to bring an end to this ordeal of not having a retirement scheme at the end of the day, my lord.
Lordship, with regard to the ad hoc teachers,
281 is what lordship is disposing of right now. 281 is
But
ad hoc.
as far
Come to
as
that.
we'll come to 360.
We'll come to that.
I have to close this one. Anyway, order will follow before the parties.
And in item 360, my lord, perhaps the EPF would be filing their affidavit, my lord. Lordship gives a date for that.
I think that is for the affidavit we filed, Mr.
We have filed the affidavit, my lord. If
I have to file my rejoinder and she
Oh,
has
you
to
have to
file
file.
her affidavit.
Lordship,
So 360.
actually what happened, Lordship, just before vacation, the state has filed the affidavit. Our reply is totally based on the state's affidavit. So now, since we have received state's affidavit, so we will be filing our affidavit.
So you filed. You have not filed your rejoinder.
My lord, I'll need to file my rejoinder on that, my lord.
on 360, my lord, only one submission, my lord, in 360, with fresh kind of writ petition, my lord. It is not a writ remand, though it is part of the remand. So it may go before the learned single judge also, my lord. That your lordship
Once I file
consider
my
on this.
affidavit,
Let them
That
file.
aspect you
Let
let that be considered.
let
my
them
lord,
file.
once
If we find
Yes,
that
Lord, we
it is
consider
required to
this
be
aspect on
placed
this.
before the single bench, and so be it.
it'll go, my lord. There's no difficulty.
Kanika 360. Learned counsel, Mr. Aram Jamdar, learned counsel for the petitioner, has submitted that the counter affidavit filed by the state respondent has been received. However, it is prayed that the rejoinder may be allowed to be filed in due course. Ms. P. Bhattacharya, learned counsel for the respondent
Number
3, has also submitted that the said respondent desires to file a response to the said counter affidavit filed by the state respondent, for which some time is paid for the same to be filed. On premiere, the same is allowed. Let the rejoinder of the response be filed within the next date fix. This is matter after
After 3 weeks.
3 weeks. So now, see, in that case, effectively what we are doing is, we are, keeping the 360, in proceedings, and 281 will be disposed of. But they are tagged together.
But Your Lordship, the direction of the Honorable Supreme Court is in both the writ petition, my Lord, and with the limited issue,
Of
But
course,
because we have reached on consensus, we have reached on the party
280
have.
Lordships is disposing of that is final at
Fine,
281,
fine.
and 360, my
It
Lord,
should
will have it
not
disposed
come
on the next day either
it should not
to go before
my
the
way
single judge,
I
or
think that 360 is not maintainable.
Anyway, that
we
will be
will
your
argue after
stand.
the rejoinder is filed, my Lord.
This is
And
matter
how
after
it
3
will
weeks.
come.
Perhaps you have to go to single.
You have to.
We
because-
have to follow the procedure, my Lord. There's no difficulty.
Let the
We'll do it.
response be filed.
Only the agenda on the next day, my Lord, we can have it decided.
pertinent issue, because that would decide your case, whether it was prior or
It
after.
will have a bearing in the case, either this way or that way, because they will have to either accept or deny. Because it was supposed to be communicated to them, but as of now, it is not accepted by them.
I'll give you a last chance.
Yes, madam.
1 week,
2 weeks, madam.
2018 matter.
Yes, madam.
If in the next case, if they fail to submit things,
That's what I
we'll
said.
continue the hearing.
That's what. Mr. S. N. Gupta, then additional senior GA, yet again sought for accommodation and has made a prayer that the affidavit which is supposed to be filed, additional affidavit which is supposed to be filed on behalf of the state respondent be allowed to be filed within the next date fixed, definitely. This court has noted that this matter is a long pending one and is posted and has been posted for hearing for quite some time. Be that as it may, on prayer made, the same is allowed. They said additional affidavit is to be filed within the next date fix, failing which matter to continue for hearing.
Managing committee was approved by order dated 15th of January.
No, but you see, even if we say that the managing committee has been constituted and approved,
Lordship, yes.
that would not be relevant because
because
at the relevant point of time, the managing committee is not.
Lordship, it's
functional.
true, Your Lordship, because the order of termination was issued by the managing committee, Your Lordship. So if
the
there
then
is a
managing
change, if a change of person, Your Lordship, then the petitioner will have to implement those new body, Your Lordship.
Lordship, as far as I could understand, since the managing committee is approved by the government, that means maybe the school will reopen. A managing committee is newly formed now. Maybe they'll decide over that, Lordship, whether the school will reopen or not.
Or you see, off the records, you can approach the managing committee.
Because now, since it's
approach the managing committee, the new managing committee, and see if there is a change of mind and change of heart, the matter could be resolved.
Lordship, we are open to that, Lordship. We are ready from
similarly, you advise your client
Yes, Your Lordship.
for the interest of the school.
Yes, Your Lordship.
Otherwise, we cannot just allow school to be non-functional. Students' career and life are at stake. And in this case, I think the government is playing a very constructive role.
Lordship.
A week's time only you will do, Your Lordship.
2 weeks.
Let me a week's time, Your Lordship.
Week, then
Yes,
fine.
sir.
Please do.
Your Lordship, yes.
Mr. Ndishulai, then AG has submitted that it is reliably learned that a new managing committee has been constituted as far as the school in question is concerned. However, details of such constitution or approval by the government could not be presented before the court today, for which some time is prayed for the same to be made known to this court. On premade, the same is allowed. However, such detail may be placed before this court in additional affidavit. This is matter to 1 week.
By an additional affidavit.
Yes, because that would be, it has to be on the court. In case they are required to
Lordship.
implement them.
Lordship.
Apply, Your Lordship.
All right, Lordship.
Lord, I'd like to mention item number 10. Where this matter be taken after 2 weeks.
Your Honor, this case is a very small case since 2020. It's got drafted, and all the SPV fund is almost exhausted. So there's no point to hear it after. We are aggrieved by diversion of the fund from other department.
How will that Anyway, we'll see.
After 2
Since
weeks.
he asking for 10. 1 week?
2 weeks.
2 weeks? Yes, as has been. You see, this 2020 matter you have to dispose of. Yes. On permit by the state respondent. State respondent?
State.
Not objected to a petitioner. This is matter 2 weeks.
Similar prayer for item number 13.
Item number?
13.
13.
No objection, Your Worship.
On permit by the state respondent. Not objected to by appellant. This is matter after 3 weeks.
Hello.
Mr. Manta is here in this case.
Yes, ma'am.
Lordship, I'm for respondent number 3.
Fine.
Please, Lordship. Lordship, I beg to make a mention item number 14, Your Lordship. Lordship, I pray for 2 more weeks accommodation, Your Lordship. Senior counsel is having some difficulties, Your Lordship.
On permit by the petitioner, this is matter after 2 weeks.
Highly obliged, Lordship.
Obliged.
My lord, I could not see the counsel for the appellant in this criminal appeal, my lord. I was praying for some 2 weeks time, my lord, item number 7. Had he been here, it would have been more convenient. In the morning he was there, Mr. P. You have been.
But you should have sought his consent.
I had sought his item 7. Oh, Lord. He wants to take instruction.
As is on next in to
So any objection to the prayer for adjournment?
no, yeah.
Already over, my lord, pending this appeal.
Oh.
So he wanted to take instruction. We had a discussion in the morning.
You could have also checked. No, there's nothing wrong with that.
No, he wanted to take instruction from us.
He wanted to take instruction, no doubt. But you see, you are more
Yes, my lord,
you are more in touch
according
with
to
the
my
authorities
record-
than anybody else.
According to my record, there is no scope for him. But then he wanted that no likelihood that the period is already over.
Yes. Is
So
it?
according to me, there is still scope for hearing the appeal and maybe further detention is required. But
Other detention?
the detention should continue for some more months, my lord. Another 6 months and another 2 months remaining. According to me, 8 months. According to him, it is already over.
So we can
So
check it out.
dispute is there itself. Prosecution version is that we want to keep him more inside and they want to come out quickly.
What is this case about?
376 conviction.
376. On permit by the state respondent. Not objected to by appellant. This is matter after 3 weeks.
Obliged, my lord.
May it please, Your Lordship, I beg to mention item number 15, Your Lordship. It's a joint prayer, Your Lordship. 15.
Lordship, I have no objection.
15.
15, Lordship.
On permit by the parties. This is matter after 3 weeks.
3 weeks.
Much obliged, Your Lordship. Your Lordship, similar prayer for item number 16 as well, Your Lordship.
Your Lordship, they have already informed us we have no objection, Your Lordship.
On permit by respondent, not objected to by petitioner. This is matter after 3 weeks.
3 weeks, Your Lordship. Obliged, Your Lordship.
May I please, Your Lordship, I beg to mention item number 8.
Practically, we have nothing left.
8. In this matter, we will be filing a rejoinder affidavit, my lord.
Rejoinder?
Yes.
Number 8, right?
Yes, ma'am, it's connected to number 1.
The matter is already posted for hearing.
Yes, but on the last order, Your Lordship asked us to if there is.
Oh. Rejoinder is yet to be filed.
And for respondent 1 and 2.
For striking out the name of the
Lordship.
respondent number
1 and 2.
1 and 2.
For item number 1, and this is for item number 8.
This is 8.
2 and 3.
Same prayer.
It's a connected.
Are you there in item number 1?
No, I'm not.
But actually, it should be tagged together, Lordship, if I may make that submission. That is still in the order column, my Lord. Today, and listed today, item number 1.
No, item number 1 is for admission hearing.
Lordship.
Yes, perhaps we may pose it for orders. Let's see.
Lordship.
Weeks, my lord.
On prayer made by the petitioner, seeking more time to file the rejoinder affidavit, which could not be done so today. Matters adjourned. Let's just see after 2 weeks.
Applied, Lordship.
Daily course list, item number 1.
May it please your Lordship. Lordship, this matter is fixed for admission hearing, my Lord. I pray for some time, Lordship.
In the other matter, you are read as a respondent.
Lordship.
Here
we are the petitioner, Lordship.
There is no cross purpose here.
Lordship, actually over here we what we have challenged was the stance of the Lokayukta, and in that matter, I'm yet to get a copy of that, my Lord. Show me that other matter. Petition. Similarly, in this matter, Lordship, the petitioner has also challenged the stance of the Lokayukta, but they have made us also the respondents here in Lordship.
Course of action is different.
Course of action is nearly the same, Lordship, because the stance of the Lokayukta is being challenged in both cases, Lordship. I pray that if
this is with regard to a complaint,
an order, Lordship, whereby the Lokayukta had passed certain directions to the police, Lordship, to take action, and we are challenging that order, my Lord.
In the other case, we are not.
No, Lordship. Over here, the petitioner, an individual, had challenged, my Lord, the impugn order passed by the Lokayukta, Lordship. Lordship, if possible, may both the matters be tagged together, Lordship?
No, we will not tag it together. We may post it on the same date.
Lordship.
Not necessarily tagged.
My Lord, my Lord.
That would
Lordship.
Might create confusion later.
Lordship.
On prayer made by the parties, let's this matter after 2 weeks. You have 2 weeks, no?
Much obliged, Lordship.
Item number 2.
My Lord, I pray for another 3 weeks' time to file my affidavit.
What is required here?
To
file an affidavit to bring on record the certificate of the substitution of the respondent number 5, Your Lordship, in this case.
The legal heir of distinct respondent number 5.
You have to supply the name of the legal heirs.
Yes, he has to file by way of
affidavit.
Respondent here has been making seems.
Yeah, but that is not necessary. You see, what you could do is, since he is the petitioner, you can always give him the names, and he has to take steps.
That has to be done, but the only thing I have to does have already supplied.
You got the list of those names?
No, the name of the legal heir.
So file by way of an affidavit, Your Lordship, because if there is any objection to that, I can address my objection, Your Lordship.
Lordship, actually that was submitted before this Honorable Court orally, Lordship, and this court was of the view that it should be made by way of an affidavit,
yes,
Lordship. It cannot be submitted orally before this Honorable Court.
No, the only thing is, I think that is with regard to the death certificate, isn't it?
No, that has been
the
produced
legal
by
heir, the name of the legal heir, Lordship.
Oh.
Death certificate is already on record, my Lord.
Yes, Your Lordship.
Okay, it's only
Lordship.
So I pray for 3 weeks' time at least to furnish the name, because I have to.
It's taking too long, Mr.
3 weeks' time to furnish the name of this thing.
The matter has
1
been.
week is good enough. Why 3 weeks?
2 weeks, because it's very difficult to communicate with this thing because this thing because network problem and all.
Which is why I'm before your lordship seeking your lordship indulgence to get some development, your lordship, in those villages, your lordship. The problem is because they're stopping the development.
That is the crux of the
Lordship.
matter. So without hearing the parties on that, it will not be possible.
But the irony here, I can contact my clients, your lordship. I can contact the petitioners.
You're from the same village.
Yes, your lordship.
You change your mobile network.
Sometimes the mobile is not reachable and all, and there's no this thing.
Do that, but I think no more dates will be allowed.
For six months, your lordship, this matter has been dragging.
Unnecessarily. 2 weeks then.
2 weeks more.
Last chance, your lordship.
Another counsel for the respondent 5, Mr. Sanghija, has submitted that the list of the legal heirs, the names of the legal heirs of the deceased respondent 5 could not be filed, could not be placed before this court by way of an affidavit on account of certain difficulty as far as communication is concerned. It is prayed that one more opportunity be given for this said affidavit to be filed. On pre-made, the same is allowed. Let the said affidavit be filed within the next date fix. This is matter to 2 weeks.
Mashallah.
2 to 6, your lordship.
Same order.
Same order.
Same order.
Item number 12.
My lord, this is the Mekufet matter where the retired employees, after getting the gratuity, have claimed for the interest also, my lord. The only issue, one issue was involved is that whether we have delayed in payment of the gratuity, thereby entitling the petitioners for the interest envisaged under section 7(3)(a) of the Payment of Gratuity Act. They have filed their written submissions already, and my written submissions are ready, my lord. I'll file in the course of the day. On the next day, my lord, may pass an order, my lord.
My lord, we have already filed our written argument, and the oral argument is also been advanced before this honorable court, Your Honor. My
Oral
lord.
argument done.
Oral argument has been done, I friend.
You file your written.
Yes, I'm filing in the course
on
of
the
the
next
day,
day. You please
Yes.
refresh the court on the.
Yes, my lord.
At least the main points.
Yes, my lord.
A copy may be given to us. My
We'll
lord.
give them.
They'll
We'll
give
give
you
them. We'll give them a copy.
Mr. P. Open and a counsel for the respondent. You are for respondent 2.
My lord, I am for
What
respondent.
state? What role has the state got to play?
State, my lord, to the limit that if this court comes to a conclusion that they are interested or they are entitled to interest, then the money has to come from them because they have been supporting us to that extent, my lord. So actually, they also have a very important role to defend. But anyway,
It would not concern the state to that.
my lord.
extent. Because if they are, directed to pay, then perhaps.
Yeah, the main fight between the Mekofet and the petitioners. That is the employees' lordship. If we succeed,
If you succeed, then
the state has to pay.
the fight will be between you and the state. How to get the money from them?
Yes.
My lord. So in the course of the day, I'll be filing before I'll give to the court master.
Mr. P. Win, counsel for the respondent 2 has submitted that the written argument is ready and may be allowed to be filed in the course of the day. As far as state is concerned, are you filing your written argument?
The counter also. I have to ask myself. They have not filed the counter also because
No, they have. Earlier, the senior counsel has submitted that they will rely on our counter.
think that has gone somewhere in
Yes, my lord.
course of on pre-made. This is matter up to 1 week.
1 week, my lord. Obliged.